11 and 12 respondents.
My lady, may I start? Sorry. My lady, may I start?
Proceed.
Thank you so much. It's my pleasure to appear before you, my lady Chief Justice and President of the Supreme Court, and my lords, my ladies, Justices of the Supreme Court. My name is Ongoya. I appear together with Mr. Ogada for the 11th and 12th respondents in the appeal. In our 55 minutes, I would endeavor to use 30 minutes and reserve 25 minutes for my colleague, Mr. Ogada, to deal with the remaining issues that we have organized ourselves to deal with. In terms of filings, I would invite you, in addition to considering the petition number 402 that was before the High Court, to also consider the grounds of objection dated 18th October 2021, as well as our written submissions dated 9th of December 2021, and our case digest and bundle of authorities appearing in 3 volumes dated 22nd December 2021. In the interest of time, I would seek to just draw the court's attention to the following matters that I consider fundamental and overarching as you read those voluminous submissions and authorities. First, my lords, my ladies, we will remind each other that we have a history as a country, and that history has taught us some lessons, some of them very fundamental lessons. Fortunately for us, a bulk of the council appearing at this podium, and my lords, my ladies, seeking to make this monumental determination, you have been a part of that history as citizens of this country. And that we should never let down the generations that will follow us by delivering a verdict that may make generations to come to have to live through some of the pains we have lived through as a country. Part of those pains were captured by retired Justice Aaron Gitonga Ringera in the case of Ongoya versus the Attorney General, which you have been referred to, and which I'll implore you to read and have inform your verdict. And to call you to consider that history, my ladies, my lords, is not to invite you to engage in extra-legal considerations. Parliament has done the same thing in Section 3 of the Supreme Court Act. It has asked you that at all times you must endeavor to give us an authoritative and impartial interpretation of this Constitution, and in so doing, to develop jurisprudence that respects that history, so that attempts at clawing back on the Constitution that appear innocuous sometimes, you must be hawk-eyed to see them for what they are, particularly if they are dangerous rodents. Because again, we know that a dangerous rodent will chip away bit by bit, but eventually bring down huge infrastructure. So, in terms of the development of the dispute now before you, I would ask my ladies and my lords to remember that before this dispute was determined by the High Court and eventually the Court of Appeal, there were 2 advisory opinions that were sought before this court by the county assemblies of Nandi and Kericho and the county governor of Makueni. My lords, my ladies, in your wisdom, and we respect that, you directed that you will not exercise jurisdiction over those opinions to allow this dispute to go through the formal dispute processing mechanisms from the High Court up to the level it has reached. I say that was wise because this dispute has therefore had a benefit of the contribution of dozens of lawyers and a number of persons not formally schooled in legal training, and it has had the benefit of reasoning by a dozen superior court judges, 5 in the High Court and 7 in the Court of Appeal. Without suggesting that you are bound by the decisions of the High Court or the Court of Appeal, I submit that a product of the minds of a dozen superior court justices is not for dismissal by a wave of the hand. It must be taken seriously, and an element of deference must be given to it so that any disagreement with it must be after serious soul-searching and serious reflections. So that this court, I submit respectfully, should approach the reasoning of the 5 High Court judges and the 7 Court of Appeal judges with a substantial measure of deference. I submit that it's a sound principle of appellate advocacy and appellate judicial decision-making processes that when we're dealing with a second appeal, as is the case here, it is not appropriate to reintroduce and reopen for consideration concurrent factual findings of the Court of First Instance, in this case the High Court, and the Court of First Appeal, in this case the Court of Appeal. If we take that principle in consideration, we then must dispose of some 2 matters with a measure of ease, my lords, my ladies. As a matter of fact, the High Court looked at the evidence before it relating to public participation in the process now before you. The Court of Appeal, as a court of first appeal, had an obligation, and it reevaluated the material that was before the High Court and came to its own conclusion, and the conclusion was insufficiency of public participation as a matter of fact. I submit respectfully that it is not open for counsel appearing before you or for this court in its decision-making process to reopen that factual issue as to whether there was, in fact, sufficient public participation. As a matter of fact, the High Court, as a court of first instance, and the Court of Appeal exercising that jurisdiction I've alluded to, re-evaluated the question of who initiated this process. And it came to the conclusion that it was the President of the Republic of Kenya who initiated this process. It is not open for this court to reopen that question of fact. And that, therefore, will dispose of a number of questions that have preoccupied the minds of many counsel who have appeared before you today. Having said that, allow me to come to the specific issue that was introduced in the judicial system by the 11th and the 12th respondents now before you, that's Mr. Juma and Mr. Ongoya, which led to the order at paragraph 495A, Roman 12 of the lead judgment of Justice Musinga, in the terms that the second schedule to the Constitution of Kenya Amendment Bill, and these words are important, my lords, my ladies, insofar as it purports to predetermine the allocation of proposed additional 70 constituencies and to direct the Independent Electoral and Boundaries Commission on its functions of constituency delimitation is unconstitutional, with one dissent from Lady Justice C. Charlie. That qualification of what was declared unconstitutional is important, and I emphasize it because of the submissions by my very senior learned colleague, Mr. Karori, the day before yesterday. The court in fact found that the provision of the Constitution relating to the number of constituencies in Kenya is amendable without necessarily taking recourse to the four-tier process that the court identified. What the court had an issue with was the allocation of the proposed additional 70 constituencies and the direction of the IEBC on its function of constituency delimitation. When you retire to interrogate whether the court was right or wrong on this question, I was warned that when we tell you when you retire, a lot of laymen think that you'll have to wait for your retirement age before you return here with a verdict. So I use that word advisedly in the technical sense of it. It's important for my lords, my ladies, to ask yourself this question: how did the court of first instance reach this conclusion, and how did the court of first appeal confirm this conclusion? A good starting point for me is what the judgment of the court of first instance says at paragraph 469. It's important that you reflect on what that judgment says at 469. And that will be so because the court has to answer the question, did that court use the correct methodology to reach this conclusion? Did it use the correct methods of interpretation? The court said, the stable canon of principles of interpretation of the Constitution, which have emerged as outlined above, are dictated by our constitutional text. So the court took into account the reading of the text. Heavy weather has been made on the argument that this court abandoned the text completely and converted itself into a philosophical tribunal. No, the court expressly said that it is taking account of our text. Secondly, the structure of that text. Thirdly, the nature of that text, which the court defines to mean the fact that it is a transformative charter. Next, our history, which both the Constitution at Articles 259 and 10 and statute, the Supreme Court Act, the very act that now directs this court, and binding precedents and the context. The court is telling us that it is taking on board all material parameters required for the interpretation of this Constitution for purposes of reaching that verdict. I submit respect, my lords, that to depart from that verdict, or to invite you to depart from that verdict, the petitioners before you appealing, at least the first and second appellants, had an obligation to demonstrate to you that any of those parameters was an irrelevant consideration. They have not done that. They had an obligation to show you that there was another relevant consideration that those judges were under an obligation to take into account, which they failed to take into account. They have not done that. That then takes us to paragraph 681 of the judgment of the Court of First Instance, which is the High Court. And if you look at paragraph 681, the court engaged in a detailed analysis of the history of Article 89 of the Constitution, which deals with delimitation of constituency boundaries. And the court set out 6 elements in the second schedule, 6 elements that make that second schedule violative of Article 89 of the Constitution. 6 elements. I'll not read them word for word, but you'll see 6 elements. If you go to paragraph 683 of the judgment, the courts then endeavor to elaborate on each of the 6 elements. I'm submitting, my lords and my ladies, that the High Court, as a court of first instance, used a scientific method of arriving at the conclusion that it arrived at. The jurisprudence, as I know it, is not just enough for you as a court to say, well, on my part, I would have arrived at a different conclusion, and thereby substitute the finding of the High Court with another finding. You would have an obligation to tell us which part of the history as stated by the High Court in those paragraphs is a wrong representation of our history. Not even the appellants have endeavored to point at one. Let me just highlight one example. The court said that a constituency is a unit of resource allocation in this country. The court said so. And the court said, to the extent that a constituency is a unit of resource allocation, the determination of distribution of constituencies has an effect on equity or the skewed nature of distribution of resources. And the court therefore said, to have a scientific and equitable distribution of resources, we must have a scientific distribution of constituencies. The court therefore found that since IEBC in Article 89 is subject to a science of delimitation of boundaries that eventually gives us the placement of constituencies in specific geographical areas, it was not open for us to abandon that and determine constituencies politically, to say it is just a political issue, as my learned colleague, Mr. Karori, has purported to submit before you. Again, I ask the question, which part of that method of arriving at that decision violates Article 259 on the proper principles of interpretation and Section 3 of the statute enabling this court, the Supreme Court Act, that gives this court a scientific formula of reaching scientific jurisprudence, can you possibly fault? I submit there is none that you can possibly fault. So we are told that if you predetermine the allocation of the constituency per county politically, and tell the IEBC, no, your role is now limited to just telling us where this constituency is in Nyamira, where this constituency is in Vihiga, where this constituency is in Samburu, you are hamstringing it from applying the complete methodology set out in Article 89, and to that extent, you are beginning to plant a seed of inequity. You're dealing with a country that has a clear history of inequity. So the court is using the correct formula and saying, no, let the IEBC apply its mandate under Article 89. Use the correct formula, knowing that the IEBC's word in Article 89 is not final. If the IEBC makes an error, there is an avenue available for a disturbed litigant to come to court and seek judicial review under Article 89(10) of the Constitution. The court is saying one of the elements that makes the second schedule unconstitutional is that even that right to come to court and complain by judicial review is taken away. How can we fault the court for such a scientific and principled approach to the resolution of the dispute that was before it. I submit respectfully, my lords, my ladies, that if we apply our minds objectively to the manner in which the High Court reached that verdict and the reasoning that the Court of Appeal engaged in confirming that finding, we will affirm, we reaffirm that finding. We will not disturb it. But more importantly for me, when you retire to have a conversation on this issue, you may also need to ask yourself the question, looking at the material presented before you in terms of the establishment of the task force, the BBI task force, the BBI steering committee, the various reports that they generated, and the publication of this bill, at what stage did the second schedule come into being? That's one question, my lords, my ladies, you will never run away from. Because when you're told there was public participation in even the generation of that schedule, you'll have to answer that question. At what point did the second schedule come in? You will notice that the second schedule was what the High Court judges eventually described as an endeavor to amend the Constitution and fundamentally alter it through stealth, because it's a latecomer in the whole process after the hitherto processes have all been exhausted without anyone telling us. So who was this telling us that Siaya County required this number of constituencies? Who was that among the participating public? To that extent, my lords, my ladies, and so as to invite my learned colleague to engage you in far conceptual matters that are of great impact in this litigation, I submit that once you look at that history, once you look at the relevant materials the judges took into consideration, once you consider Kenya's history as captured in various stages of review of our Constitution, at least in the latter years, partly captured in the Ongoya decision and partly captured in the commission reports, including the Kregler report that you have been referred to in depth. And once you look at the BBI process itself as it flew, you will come to the inevitable conclusion that to the extent that the second schedule of that bill purported to predetermine the allocation of the proposed constituencies to respective counties and direct the IEBC on how to delimit those constituencies, that was unconstitutional. But there's an important question that one of my lords raised yesterday, and I have to respond to it. When you go to the processing of petition number 402 before the High Court, I want you to investigate the question, what position did the IEBC take on that position? The IEBC, throughout the processing of this dispute up to the time it comes before you, has never contested this position of the 11th and 12th respondents. Never contested that position, that this second schedule is unconstitutional. Number one, I want to look at the appeal that the IEBC filed at the Court of Appeal. They did not challenge this position by the High Court. Number two, I want you to look at the appeal that that was filed on behalf of the IEBC before you. They have not challenged this concurrent finding of law by the High Court and the Court of Appeal. Which brings me to the oral representation by my very good teacher and mentor, Professor Githu Muigai, that the IEBC's position now orally at this podium is that Article 89 of the Constitution does not amount to a basic structure. First, Professor Githu Muigai told us that to him, the word basic structure means entrenched provisions. And he traced those entrenched provisions in Article 255(1). You realize that even if you use that test by Professor Githu Muigai, the independence of the judiciary and the independence of constitutional commissions, which includes the IEBC, would become part of the entrenched provisions. So that applying his own test, Article 89 would become an entrenched position, which he equalizes in terms of effect to a basic structure. And therefore, to the extent that the court at the first instance and at the second instance called it as much, we cannot fault the court for doing that. But more importantly for me, the IEBC must be taken from its word and conduct in the respective courts. by its formal findings that it has all along been satisfied by the position taken by the 11th and 12th respondents on the first part, and the position taken by the High Court and the Court of Appeal on the constitutionality of the second schedule of the Constitution. I urge you to dismiss the petition of appeal by the Attorney General. I have reason that the Attorney General in this matter was mourning louder than the bereaved, the IEBC, which was the real target of the analysis of Article 89, and we will advise it as much. Allow me, at that juncture, to invite my colleague, Mr. Ogada, to do duty regarding the other conceptual issues that are relevant to this finding.